From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Justice Department gives its most detailed explanation yet for the FBI's raid on President Trump, as a new abortion referendum on the November ballot could upend politics in Michigan. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Kim Strassel and editorial writer Mene Ukwe-Barua. President Trump has gone to court asking a judge to appoint a special master to review the material that the FBI seized during its raid on Mar-a-Lago. And late on Tuesday, the Justice Department filed its response, which includes what looks to me like the most detailed justification yet that the government has given for the raid, and similar for what was taken as a result of this. So, Kim, what's your read of what we have learned here from this Justice Department filing in court?
Well, my read is a little bit different than I think some of the headlines you're seeing in mainstream media, which is that because we now know more about what was taken and the fact that these were classified and that they were found, in places other than this storage facility, that somehow the Trump team lied and that this amounts to obstruction. Stories have pointed out that a member of the Trump legal team signed a certification saying that any all documents that were responsive to the subpoena had been returned. And yet those stories then go on to say, but according to the Justice Department, further investigation showed that was not the case. Well, here's the problem in my mind. As we noted in an editorial some time ago, the real question here comes down to classification, the power of declassification. Donald Trump's team has said that they declassified some of these documents. And if you take them at their word at that, and we could get into an argument about whether or not he really has the authority to do that, if anybody heard him, whatever. But if that's the case, and they're arguing that they returned everything that was responsive to the subpoena, is not necessarily the case that things that were left were classified if the president said he declassified them. And so I'm not sure we're any farther along than we were before. We already knew that they had retrieved some documents with classified markings. We now have a little bit more detail about where they found them and how many and et cetera, what markings were on them. But you're still left with the question that all the way back in May, even before this raid happened, the president's legal team had correspondence with the Department of Justice and the National Security Division saying, hey, don't forget the president has power to declassify documents. And there was a whole long legal memo. So that was a discussion that was being had between DOJ and the Trump team well before this raid ever happened.
Well, I would push back on that a little bit. I mean, here's what I took away from this legal filing, what I think we learned from it. First, the Justice Department says that the search of Mar-a-Lago recovered more than 100 classified documents. That was double the number that Trump and his representatives turned over voluntarily after they had said that they had done a diligent search for documents. 3 of those documents were apparently in desks in the president's office, not in this locked storage room in Mar-a-Lago. And the classification markings are really clear. Some of them had top secret cover sheets, and the filing includes a photograph of some of this material on the floor in what I presume is Mar-a-Lago. None of the secret information itself is visible, but you can read these red, yellow warning sheets, secret SCI, contains sensitive compartmentalized information. The fine print here says all individuals handling this information are required to protect it from unauthorized disclosure in the interest of the national security of the United States. And it goes on to talk about the laws, executive orders, and implementing regulations protecting that material. And to the point about whether this was declassified or not, the Justice Department also says that when the subpoena produced some documents, I'll just read here a line, neither counsel nor the custodian asserted that the former president had declassified the documents or asserted any claim of executive privilege. Counsel handled them in a manner that suggested counsel believed that the documents were classified. And so, Mene, it gets to a question of, I grant that the president has very broad declassification authority. It gets to the question of whether you believe the word of Donald Trump that he did, in fact, declassify these, which is, again, is what he's saying here is him on Trump's social. Terrible the way the FBI during the raid of Mar-a-Lago threw documents haphazardly all over the floor, perhaps pretending it was me that did it, and then started taking pictures for the public to see, thought they wanted them kept secret. Luckily, I declassified. And the question here seems to be whether you believe that that's true, Monet.
Yeah, I guess that's right. I mean, I think we can definitely agree that if the Trump team does face a charge here and ends up challenging this in court, that there is going to be a ruling on what is the extent of the president's declassification powers and what ways does he need to approach that declassification. I do think that it's very possible that courts will rule that the president is not required to formally promulgate the fact that he's declassified some of these documents, that there's very little official protocol surrounding how he does it. And so his opponents, the Department of Justice, would have a very tough case to make, suggesting that, that the documents were not really classified if Trump is able to claim that he did this before the subpoena was served. But I do think that in terms of just our common sense reading of the classification of the documents, sort of as a public watching all this unfold, the fact that the Trump team doesn't seem to have made the argument that the documents were declassified until after the raid of Mar-a-Lago in August suggests that it's very possible that he actually did not declassify the documents beforehand. Of course, there's no way for us to know that. But you would imagine that if he had done that, then that would be something that he would mention up front while he was in this months-long encounter with the Department of Justice, as opposed to only saving it after the raid. If it was a legal strategy of his to save declassification as a trump card, he didn't want to have to mention it. But then he, after the raid is saying, okay, this is something that is going to clear me of legal peril, then, perhaps that's a valid legal strategy. But in terms of the smell test, if you will, whether we believe that he declassified the documents beforehand, I think we should count it as a point of evidence against that possibility that he doesn't seem to have made that argument until recently.
And I would add that, I think this information makes Trump's conduct look, to my eye, more reckless and non-compliant, which was one of the questions when the FBI executed the raid. But I still think this doesn't affect people's judgments about the prudential matter. And the first one is whether the information that was alleged to be here justified what the FBI did in raiding the home of a former president, which they had to have known was going to be incredibly politically inflammatory. And the difficulty with figuring out that judgment is, as a member of the public, I don't have a top secret security clearance. And so there's no way for us to know what it actually was that the information the FBI thought was there. The second prudential judgment, Kim, I think, is whether the case that the Justice Department is building here rises to the level of making some sort of a criminal charge out of it, which you're seeing in the public debate rising, some people making the argument that it ought to be. And part of the issue there, again, goes to what is actually in this classified material, whether it rises to that level, but also, how other people, other prominent politicians who probably don't need to be named, have been treated after also mishandling classified material.
Yeah, and before I address this, just one thing, because I want to go to Monet's point about how Trump supposedly didn't say that he did this until recently, declassification. I just would point everybody again back to this May 25th letter. It was a 3-page letter from the Trump legal team to the Department of Justice, in which several very substantive sections of it were all about a president's power to declassify. Now, presumably, they would not make that argument to the Department of Justice unless their argument was that Trump had material that he had declassified. So I'm just pointing that out. But to the point about the prudential question of whether or not you engage in such a high-stakes raid and then you bring any charges, yeah, look, do we really want to end up getting into a situation where we have charges about the mishandling of classified information and we have a protracted, extended legal fight in court about the theoretical presidential ability to declassify and when that happens and who has to hear it? Whereas I think the argument could easily have been made that the Department of Justice could have done this in a civil fashion, meaning civil versus criminal. They could have put out a subpoena for this. If they felt they weren't getting what they wanted, they could have put a restraining order on the president or held him in contempt of something without going full raid in a way that is unprecedented and really, once again, roils the body politic. Now we're having people talking about whether or not there could be charges for obstruction. And my problem with that is, to get to obstruction, you have to believe that there is some kind of grand plan that Trump had here, that he wanted to secret away these documents and use them for some nefarious purpose and keep them out of the Department of Justice's hands. And, this reminds me very much of the collusion narrative, the same thing where they spent all this time dreaming up these conspiracy theories about how Trump was interacting with Russia based in the end, we know, on nothing more than some very banal meetings and a bunch of gossip. And I would quote here John Bolton, former security official in the Trump administration, no big fan of Donald Trump, was on a podcast recently, and here's how he saw it, which was a much more simple explanation, which I kind of, as a result, it really rings with me. He said, I think he just had an inquisitive instinct. He would see things in intelligence briefings, a picture, a graph, something like that, usually not lengthy written material, that's for sure. But he'd say, well, I want to keep that. And it would sort of end up in a pile on his desk. Again, a lot of Trump's critics have great theories about how he's going to use this information to blackmail people and its leverage over other people. I think that gives Trump too much credit. I just think he brought things into his possession thinking at some point it'd be interesting to look at it later, and that's how it happened. That doesn't excuse it, but I think you overstate the case against Trump, end quote, if you end up going further. I think that there's something to that. And that's something that ought to be in prosecutors' minds if they think about going down the road of obstruction.
Yeah, I think that's a good point, and this can be one of those situations where both sides have some flaws to their arguments here, and it certainly seems like a prosecution on this basis would look to half the country after the Hillary Clinton email scandal of having a private server as Secretary of State as unequal justice. On the other hand, I also find it hard on the public record to understand, frankly, and defend what President Trump seems to have done here. Some of this information, as we've been discussing, Trump might have thought they were mementos, letters from foreign leaders. On the other hand, if you look at the photo and it's pages of things with secret cover sheets and things where you can see White House letterhead on them, it appears, the seal of the United States, the seal of the president, and even setting aside whether or not they're classified or declassified, a lot of this stuff looks like government records. And that's another thing that the Justice Department says in its filing. It says the former president lacks standing to seek judicial relief or oversight as to the presidential records because those records do not belong to him. The Presidential Records Act makes clear the United States has complete ownership, possession, and control of them. And so, Monet, maybe I will wait forever for an answer to this, but I also don't quite understand why President Trump didn't simply work in good faith with the current executive branch to get this material, if it's really government records, back to the government, if it's classified, to a proper holding site for classified material. I don't quite understand his position.
Well, I'm a little bit more skeptical of the Justice Department's argument here that all these records necessarily are the full and unambiguous property of the United States of America, and that President Trump, as a former president, does not necessarily have any potential claim to some of them. I think that that is something that we can't really determine definitively until we know what the content of the documents is, and I'm sure that different types of documents would have sort of different laws governing sort of the degree of privacy attached to them. But specifically, I'm thinking of the sort of attorney privilege claim that President Trump has made sort of in contesting which documents can be reviewed now. It's very possible, again, that there are certain things in some of these documents that are relevant to him as an individual, or that he might have a stronger claim to be able to possess. And particularly if he had chosen to declassify them, then sort of their top secret nature would not necessarily preclude him from having them at his private residence. We can say is that seems as if Trump certainly should have been a lot more forthright about his reason for holding on to some of these things. It's very possible that many of the documents, or maybe the majority of them, are things that the public would agree should not rightfully be in the possession of a former president once he's left office, kept at his private residence. But I think that there probably would be a sort of very bitter, detailed fight that would go deep into the weeds regarding what his claim might be over certain types of documents.